The journey of mediation in India has been a long one. We finally have a standalone statute focusing only on mediation. In the recent monsoon session of the Parliament, both houses passed the Mediation Bill. It received the presidential assent in September 2023 and came to be referred to as the Mediation Act 2023. But what exactly does the Mediation Act 2023 mean for us? To start with, it provides a framework and some kind of certainty around mediation. The Mediation Act recognizes pre-litigation mediation, online and community mediation, and encompasses the term conciliation to align with international practice. It does away with Part 3 of the Arbitration and Conciliation Act dealing with conciliation. The Mediation Act introduces enforcement of settlement agreements arising out of mediations conducted in India. It would apply to international mediations, basically where one of the parties is outside India. It establishes the Mediation Council of India to regulate mediators and mediation institutions. The statute sets time limits for mediation proceedings, maintains confidentiality, and protects privileged communications exchanged during mediation. It introduces guidelines for mediator appointments as well. The Mediation Act provides for an illustrative list of disputes or matters which are not fit for mediation, which may prove to be an effective guidance in case of any ambiguity in the nature of disputes which can be settled through mediation. Thus, we can say the Mediation Act in a way goes a step ahead of the Arbitration and Conciliation Act, which has left issues related to non-arbitrability of disputes to judicial precedents. The Mediation Act also provides for suitable interim orders in court-referred mediations to protect the interests of any party. However, the Mediation Act does not specify the nature and extent of such interim orders, unlike Section 9 of the Arbitration and Conciliation Act. As regards enforcement, a mediated settlement agreement is final and binding on the parties and shall be enforceable as a decree or judgment of a court. Now coming to challenge. The grounds for challenging a mediated settlement agreement are fourfold, that is, existence of fraud, corruption, impersonation, and where the subject matter of dispute was not subject to mediation. While the Mediation Act is well intended by restricting the grounds of challenge, they may be subjected to abuse by recalcitrant parties. Therefore, the interpretation by way of judicial precedents may prove some guidance in this respect. The Mediation Act introduces amendments to existing statutes like the Consumer Protection Act, Commercial Codes Act, Indian Contract Act, etc., to align them with the new framework under the mediation statute. Undoubtedly, the Mediation Act is highly promising. However, there are a few misses, and I'll be discussing one of the key misses here. For example, the Mediation Act in its current form does not recognize and enforce settlement agreements arising out of mediations that did not take place in India. Although India became a signatory to the Singapore Convention on Mediation on 7th August 2019, it is yet to be ratified. Therefore, the Mediation Act does not adopt the Singapore Convention on Mediation, which is akin to the adoption of the New York Convention for Enforcement of Arbitral Awards in the Arbitration and Conciliation Act 1996. It is to be importantly noted that the Singapore Convention contemplates and provides a framework for cross-border enforcement of settlement agreements resulting from international mediation. Therefore, it may be crucial for India to ratify and adopt the Singapore Convention on Mediation for a more robust framework on mediation.